You sure you only had half a pitcher? How long ago did you say that was?
About 2 hours ago.
2 hours. It must have been a big pitcher.
That's my client. He was arrested for DUI and blew below the legal limit. Then the officer requested that he take a urine test. It's my position that the search of my client's urine violated his Fourth Amendment right to be free from governmental intrusion. We're gonna go to the courtroom and listen to a hearing on the case. But first, let me bring you up to speed. He was stopped for a speeding violation.
The reason I stopped you is your speed back there.
Yes, sir.
You're doing 58 and 45.
Which led to him performing roadside sobriety exercises.
Go ahead and start.
1,000.
Your left hand.
3,000. 4,000.
Your left hand.
5,000. 6,000.
Your right.
7,000. 8,000.
Right.
9,000.
And you're right.
1.
Alright, right now you're being arrested for DUI, alright?
After the field sobriety exercises, he was arrested for DUI, taken to the police department, and ordered to submit to a breath test. His breath test results were below the legal limit. This prompted the officer to request a urine test. It came back hot for THC, delta-9 tetrahydrocannabinol, marijuana. There is no evidence of drug use anywhere in this stop. No paraphernalia, no odor, no admission, nothing. That means there's no reasonable suspicion, and I believe this search is unconstitutional. Let's go to the courtroom and listen to the prosecutor question the police officer on direct examination.
What happened after you completed the field sobriety exercises?
I placed the defendant in handcuffs,
And what did you do after that?
escorted into my vehicle.
And did you take him anywhere in your vehicle?
I did. I took him to the police department.
What happened after he had got to the police department?
He was requested to take a breathalyzer.
And do you know if he did provide a blood sample?
He did, to Officer Howell.
And do you know what the results of that were?
I do.
What was that?
I believe it was a .054.
0.054?
I believe so, yes.
And what did you do after you learned of the breath result?
I asked the defendant to submit to a urine.
And why did you ask for a urine sample?
Due to the observations I've seen on scene for the DUI.
Did you feel that the observations that you had seen were consistent with a flow of 0.054?
No,
Did you request the urine sample because you felt that he may have been impaired from
I
drugs?
believe there was other impairments, yes.
Nothing further at this time, Your Honor.
After direct examination, the judge will give the opposing party the opportunity to cross-examine the witness. If you pay attention, you'll notice the judge says, on those issues, when he refers to cross-examination. This is because cross-examination is limited to the issues that were addressed on direct examination.
Cross-examination on those issues?
Yes, Your Honor. After the field sobriety exercise, you placed him under arrest, correct?
Correct.
Transported to the police department?
Yes.
And when you saw the breath test results of 0.05, 0.051, 0.051, 0.051, whatever the results were, at that point in time, you requested urine, correct?
I asked him for urine, yes.
When you requested the urine, did you read implied consent for urine?
I'm not sure if Officer Howell did or not.
All right. If you would have refused to provide the urine sample, his license would have been suspended.
Correct.
And at that point in time, was there anything in the car that led you to believe that he was smoking weed?
No.
Was there anything at all besides the breath test results that led you to believe he was smoking weed?
No.
Taking any other drugs?
No.
Any paraphernalia?
There was no observations of anything in his vehicle, no. Or on his person.
So no observations besides the breath test results of any drug use?
No.
No further questions.
Now that we're done with cross-examination, it's time to move into arguments. It's my position that the police officer did not have reasonable suspicion to believe that drugs were going to be in the urine and therefore could not request a urine test. If the judge agrees with me, that evidence will be excluded and the jury will never hear about it if this case goes to a jury trial. If the judge agrees with the state and says the search was legal, then the state can argue that not only was there a low level of alcohol in the system at 0.053, there was also THC in the urine, which suggests he was also high on marijuana. Question for the comments. Do you believe police officers should be allowed to turn off their body cameras during their shift. Let me know what you think. Let's listen to those arguments.
So the law on implied consent and especially with regard to urinalysis is that there has to be reasonable suspicion to believe the person was under the influence of a chemical or controlled substance listed in 893 or 877. Just because somebody blows below the legal limit does not give you a sufficient nexus to request a urine test. You have to have something, you have to have reasonable suspicion that drugs are involved. And in this particular case, the testimony from the officer is quite clear. No odor of marijuana, no indication of drug use, no paraphernalia. The only thing the officer believed drugs were involved with was after he blows below the legal limit and he says, oh crap, I gotta get something, and then requests a urine test. And so that urine test should be excluded based upon lack of reasonable suspicion for the blood test or for the urine test itself. Some of these county court opinions have found that an inconsistent result with degree of impairment may be grounds to get the nexus there. So if you have somebody, they can't even stand up straight, they're walking down, they just fall over, they're so hammered, and then they blow a 000, some of these county court opinions will rule, there's probably sufficient nexus there because that impairment is inconsistent with what's being observed by the officer, as high as in this instant case. To the contrary, breath test readings of 0.051 and 0.044, as in this case, were sufficient to explain the impairment observed. The court watched the video. This is definitely not the worst field sobriety exercise this court's ever seen, that any of us have ever seen, or even the officer's ever seen. These field sobriety exercises are maybe at the 0.05 to 0.8 level. That's totally consistent with the breath test results. For the officer to make the jump that there is now some other type of drug on board without any evidence of paraphernalia, drug use, smell, admissions, without anything else, this urine test was taken without reasonable suspicion.
Ms. Costin, do you have any cases on point, man?
I do, Your Honor. The officer testified as to his observations and as to his conclusion that what he had witnessed on scene, and he has conducted not only his training in the field sobriety exercises and his training in DUIs through the academy and through his in-services, he's also been a part of about 100 DUI investigations, about 30 of those conducted by himself, that these results were inconsistent with the breath test that he was seeing. I think that in contention with one of the cases presented by the defense where the breath tests were not that high, in two of these cases the breath tests are higher than we have here, and it was found reasonable based on the observations that the urine be provided.
Okay, I'm going to take that under advisement. I'm going to try to get you an order out Monday or Tuesday on the whether the request for the FS or for the urines should be admissible or not. Okay.
Yes, Your Honor.
All right. Thank you, folks. Appreciate your help.
Okay, so the judge wanted to take this under advisement. He wants to review the case law, listen to the testimony again, and make a good decision. You can't fault him for that. A few days later, we got an order in. The judge agreed. The urine test was suppressed. The judge ruled that the police officer did not have reasonable suspicion to request the urine sample. If you watch the other video on this case, you'll learn that the field sobriety tests were suppressed as well. In order for the state to prove this case, they're going to have to establish that my client was impaired without using any field sobriety exercises and without any mention of the urine toxicology results with a breath test level at a 0.053. That's a tough sell. Once the judge's ruling went through, state attorney's office dropped the case. Another DUI dismissed. Hit hard.